The webinar will begin in 1 minute. Welcome, everyone. We are pleased that you have joined us for today's webinar titled The Supreme Court's Decision in Connelly. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Linus Sugis. Linus is the president of Advanced Underwriting Consultants. He and his team answer tax and technical questions posed by producers every day. Linus also spent 14 years working in the home office of a life insurance company in various roles. He also started, ran, and sold an estate planning law practice in the Nashville area. Linus will draw on his legal and life insurance experience during today's webinar, and here he is.
Thank you very much, Amber, and welcome everyone. There have been few court cases in recent memory that deal with life insurance and buy-sell planning in the same way that the Supreme Court's decision in Connelly did. And so I'm glad you're here for today's webinar. And for those of you listening in the recording, I'm glad you're listening as well. I think the case is important for us to know about, and we're going to talk about it in as much detail as 15 minutes will allow. Before we get into the meat of Connelly, I'd like to remind you that we put on these webinars on the first Wednesday of every month. Next month's will be on Wednesday, September 4th. These webinars are free of charge and open to anyone in the insurance and financial planning industry. Feel welcome to invite those that you think might get some value from these webinars. And if you miss a particular webinar, we do put them up on our YouTube channel shortly after they are given. Before we get started on today's topic, let's go ahead and take a look and decide on what it is that we're going to talk about in October. Hard to believe we're talking about October already, but there you go. You're going to have three choices. The first choice is reviewing Form 1099 LLC. The second choice will be on the IRS issuing Secure Act regulations that happened recently. And the third choice will be fighting with the IRS. I am going to go ahead and open the poll and give you an opportunity to vote. I'll give you about 15 seconds to go ahead and make your choice with regard to October's webinar. I see most everyone has already voted. Thank you for that. In fact, we've got 100% voting. Thank you for that. We will talk about the IRS's Secure Act regulations in October. Thanks again for voting. All right, let's go ahead and talk about the Connelly case. Here's what we're going to talk about with regard to Connelly in the next 15 minutes or so. We're going to take a brief look at the case background. We'll talk about what the lower courts said about the fight between the Connelly estate and the IRS. We'll talk about how the Supreme Court intervened and what they said. We'll talk briefly about implications and open questions from Connelly, and we'll finish with a few concluding thoughts. So let's start with the case background. This is a situation where we've got two brothers who owned a C corporation. Michael and Thomas Connelly owned a building material company in St. Louis. Michael was the majority owner and Thomas was the minority owner. And the brothers got together and entered into a buy-sell agreement. And under the buy-sell agreement, ultimately it was the company's responsibility to do the buying in the event of the death of either one of the brothers. And to help fund the obligation under the buy-sell agreement, Crown, the company, purchased $3.5 million of coverage on each of the brothers' lives, and Crown named itself the beneficiary. What happened next is that Michael died in 2013. Crown collected $3.5 million of death benefit. While the brothers had a buy-sell agreement, the buy-sell agreement itself did not set a reliable price for the buyout. So Michael's estate and the surviving owner, Thomas, had to negotiate over what the redemption price for Michael's ownership interest would be in Crown C Corporation. They finally determined or settled on a buyout price of $3 million for the 77% interest. And that's the kind of the background of the case. So how did the case end up in court? Well, the estate the executor for the estate maintained that the redemption price of $3 million was the proper value of Michael's ownership interest in the business for estate tax purposes. The IRS didn't agree. The IRS said the value of the life insurance death benefit needed to be included in the valuation, which made the business worth $2.3 million more from the IRS's perspective, which would generate a bigger estate tax liability of about $1 million. And so the parties went to court over the proper valuation of the closely held business interest. The district court, the lowest court, granted summary judgment to the IRS, and it said that it was clear to it that the value of the business must include the value of the life insurance proceeds that were collected after the death of Michael. Well, Michael's estate didn't like that decision, and it appealed to the Eighth Circuit Court of Appeals. The Eighth Circuit Court of Appeals recognized that there's a provision in the tax code that says that a buy-sell that is proper can fix the value of a business for estate tax purposes. If it's done right, the buy-sell agreement can absolutely convince the IRS that the value set forth in the buy-sell agreement is the correct value for estate tax purposes. And the Eighth Circuit Court said that this particular buy-sell agreement would not fix the value of the business for estate tax purposes because the buy-sell agreement itself did not fix the value of the business. The buyout price was actually negotiated after the death of the insured. It was negotiated between the surviving owner and the insured's estate. And that's why, in this case, Section 2703, which is the code section that says a buy-sell agreement can fix the value of the business for estate tax purposes, why it didn't work. And the Eighth Circuit kind of went into a little bit more detail about what was needed under code section 2703 for a buy-sell agreement to fix the value for estate tax purposes. It's a four-part test. First part is it's a real business agreement. Second, it's not a device to transfer the business to family members for less than a fair price. Third, the arrangement's got terms similar to arm's length transactions, that is, transactions between unrelated parties. And the fourth requirement is that the buyout price under the agreement can be determined by the agreement. And it's this last test that ended up being problematic. The buy-sell agreement provided for appraisal of the business after the owner's death to come up with the valuation. Appraisal was not actually used. The parties actually negotiated the buyout price, and that's why the Eighth Circuit said it could ignore the buy-sell agreement, and it should ignore the buy-sell agreement in coming up with an estate tax value for the insured's for the insured's ownership interest in the business. So what are the implications with regard to the Connelly decision? Well, there's some interesting things here, and some things that we've seen written about, and some things that that are troubling with regard to the Supreme Court. First of all, the first thing that's interesting is that the Supreme Court was unanimous, and the unanimity was squarely behind the IRS's interpretation of the value of the business. The Supreme Court unanimously held that the life insurance proceeds must be included in the insured's estate for estate tax purposes. And you wonder, if the Supreme Court was unanimous and all they did was affirm the appellate court, why they bothered to take the case. And I think the reason they took the case is that there was an 11th Circuit Court of Appeals opinion in the Blunt case. The 11th Circuit had ruled that a business's estate tax value, if the estate tax value included life insurance, the estate tax value of the business could be reduced by the obligation to redeem the shares on the part of the business. And so on the one hand, while life insurance would inflate the value of the business, if the business was obligated to use that life insurance to buy out the ownership interest of the deceased, they would offset each other. And that was what the Blunt case stood for. Well, the Supreme Court explicitly overruled the logic in Blunt and said that it was no longer applicable. And that's why it unanimously agreed that the IRS would win this case. And that's probably why the Supreme Court took it, because there was a difference of opinion between the 8th Circuit and the 11th Circuit about how to approach these valuation cases. And I suppose that's the bad news. So what other lessons should we take from what the Supreme Court said in Connelly? Well, there's a couple of things that Justice Thomas wrote in his opinion that are things that kind of stick out to us. And these are direct quotes lifted from the Connelly decision. The first direct quote is this: although a share redemption agreement may delineate how to set a price for the shares, it is ordinarily not dispositive for valuing the decedent's shares for the estate tax. And he cites Code Section 2703. Well, we looked at Code Section 2703, and Code Section 2703 is pretty explicit in that it says that a buy-sell agreement can fix the value of the business for estate tax purposes. It's just that under the facts in Connelly, that test failed because we couldn't determine what the value was by looking at the buy-sell agreement. And so while the quote that we pulled from Justice Thomas, the first quote from the opinion, is a little bit troubling, if you actually look at Code Section 2703, it's a little less troubling. And the second thing that Justice Thomas wrote is one that I think a lot of other people have observed about the Connelly case. This is, again, a direct quote from his opinion. A cross-purchase agreement would have allowed Thomas to purchase Michael's shares and keep Crown in the family while avoiding the risk that the insurance proceeds would increase the value of Michael's shares. And that's right. Cross-purchase arrangement under these circumstances would have been a better design because it would not have inflated the value of Michael's shares for estate tax purposes. So what are the things that we think? First thing, I think it's important for us to note, under both Blunt and Connelly, the courts decided that the requirements of Code Section 2703 had not been satisfied. So the buy-sell agreements were ignored in coming up with business valuation amounts in both cases. And so if we're going to do buy-sell planning and we're going to structure the agreement as entity purchase, let's make sure that the requirements of Code Section 2703 are going to be met. If they are met, they can fix the value of business for federal estate tax purposes. And the valuation in the agreement does not necessarily have to include the collected life insurance proceeds, right? We can come up with a formula in an entity purchase buy-sell agreement that sets a reliable price, and if it's done correctly, it will still convince the IRS that the value in the agreement is correct for estate tax purposes, and it doesn't necessarily have to include the value of the life insurance proceeds. Well, if we've got somebody who is still worried about Connelly, we can certainly tell them, look, set it up as a cross purchase and you take the issue off the table. So what other concluding thoughts might we take from the Connelly case? We've hit this thought a lot of times in our webinars in the past, but I think it's important for us to remember. Doing good buy-sell planning, it's hard. It's hard to get it right, especially for our high net worth clients who have significant closely held business interests. There are a lot of things to think about, and Connelly underscores that planning for the valuation of the business for estate tax purposes is one issue that needs to be thought about. There are many others, but it's certainly one other that needs to be thought about. The justices in the Supreme Court agreed that more thoughtful, more careful planning in the Connelly case could have avoided the fight over valuation between Thomas's estate and the IRS. And really, if we look at Connelly as an opportunity, I think it's right there in front of us. The Connelly decision gives us an opportunity to talk to our business owning clients about their existing business continuation plans. It gives us a platform to talk to new prospects about buy-sell planning. We can show off a little bit about what it is that we know about and how it is that the Supreme Court has looked at buy-sell planning so that we can seek to avoid the pitfalls inherent in the Connelly decision. So I hope you feel like that was valuable to you. For those who may have missed today's session, if you feel like somebody would get some value out of hearing it, we will post today's session to our YouTube channel before the end of the week. And at this point, I'd like to turn the program back over to Amber to close this out. Amber?
Thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, September 4th, at this same time. Next month's webinar will be titled Trust as Beneficiary of an Annuity. You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again and best wishes for continued success.